were revoked. This week, from August 31st to September 6, 2025, the President signed a total of 4 executive orders and 0 were revoked. There were 17 lawsuits either filed or updated this week. The executive actions focused on trade, national security, defense, and international relations. The first executive order, signed on September 4th, implements the United States-Japan Agreement. This agreement aims to reduce the trade deficit, boost the U.S. economy, and strengthen the manufacturing and defense industrial base. It establishes a 15% tariff on most Japanese imports, with sector-specific treatment for automobiles, aerospace, pharmaceuticals, and natural resources. Japan will increase procurements of U.S. agricultural goods and invest $550 billion in the U.S. The Department of Commerce and the Department of Homeland Security are affected. This order amends or supersedes Executive Order 14,257, Proclamation 9,704, Proclamation 9,705, Proclamation 9,888, Proclamation 10,962, and Proclamation 10,908. Japan is directly affected by this order. The second executive order, signed on September 5th, focuses on strengthening efforts to protect U.S. nationals from wrongful detention abroad. It allows the Secretary of State to designate countries that engage in or support such detentions as state sponsors of wrongful detention. The order outlines criteria for designation, responses including sanctions and travel restrictions, and conditions for terminating the designation. The Department of Homeland Security and the Department of State are affected. The third executive order, also signed on September 5th, modifies the scope of reciprocal tariffs and establishes procedures for implementing trade and security agreements. It modifies Annex 2 to Executive Order 14,257, implements tariff modifications described in the Framework Agreement with the European Union, and establishes procedures for implementing current and forthcoming trade and security framework agreements between a foreign trading partner and the United States. Authority is delegated to the Secretary of Commerce and the United States Trade Representative. The Department of Commerce, the Department of Homeland Security, the Department of State, and the Department of the Treasury are affected. This order amends or supersedes Executive Order 14,257, Executive Order 14,326, Proclamation 9,704 of March 8, 2018, Proclamation 9,705 of March 8, 2018, Proclamation 9,888 of May 17, 2019, and Proclamation 10,962 of July. The fourth executive order, signed on September 5th, directs the Secretary of Defense to use the secondary title of Secretary of War and allows the Department of Defense to be referred to as the Department of War. It requires the Secretary of War to submit a notification to Congress regarding the use of the Department of War designation and a recommendation on actions required to permanently change the name of the Department of Defense to the Department of War. The Department of Defense and the Office of Management and Budget are affected. Turning to the courts, in League of United Latin American Citizens versus Executive Office of the President in the District Court for the District of Columbia, Judge Colleen Collar-Cutelli is presiding over a case challenging Executive Order 14,248 regarding proof of U.S. citizenship on voter registration forms. This case has been consolidated with Democratic National Committee versus Trump and League of Women Voters Education Fund versus Trump. A motion for a preliminary injunction blocking enforcement of the executive order has been filed by both nonpartisan plaintiffs and Democratic Party plaintiffs, asserting violations of constitutional protections for federalism and the separation of powers. In Revolution Wind, Limited Liability Company versus Burgum in the District Court for the District of Columbia and State of Rhode Island versus United States Department of the Interior and the District Court for the District of Rhode Island, both cases involve challenges to the administration's stop work order halting construction of an offshore wind project. No updates were found this week for either case. In Newsom versus Trump in the Northern District Court of California, Judge Breyer is overseeing California Governor Gavin Newsom's lawsuit against the administration's decision to federalize members of the California National Guard. The Ninth Circuit granted the federal government a stay pending appeal on June 19th. In District of Columbia versus Trump in the District Court for the District of Columbia, the District of Columbia is challenging the deployment of the National Guard to the nation's capital without the city's consent. No updates were found this week. In President and Fellows of Harvard College versus United States Department of Health and Human Services in the District Court of Massachusetts, Judge Burroughs ruled on September 3rd that the administration's attempt to condition Harvard University's federal funding on changes to its campus policies violates the school's First Amendment rights, Title VI procedural requirements, and the Administrative Procedure Act. In Climate United Fund versus Citibank in the District Court for the District of Columbia, Judge Tanya Chutkan is presiding over a case involving the withholding of Environmental Protection Agency grant funds. A temporary restraining order enjoining the Environmental Protection Agency and Citibank from implementing the grant termination and transferring the funds elsewhere was granted in part and denied in part on March 18th. In Fairfax County School Board versus McMahon in the Eastern District of Virginia, the Fairfax County School Board is suing the Department of Education after the department put the Fairfax County Public Schools on high-risk status. No updates were found this week. In LGML versus Noam in the District Court for the District of Columbia, Judge Timothy Kelly is now assigned to the emergency class action complaint filed by unaccompanied minors challenging their pending summary removal from the United States. Judge Sparkle Suknanen initially granted a temporary restraining order to maintain the status quo. In WMM versus Trump, also known as AARP versus Trump, in the Northern District Court of Texas, Judge James Wesley Hendricks is presiding over a case regarding President Trump's proclamation to invoke the Alien Enemies Act. The Supreme Court issued a stay directing the government not to remove any member of the putative class of detainees from the United States until further order. The Supreme Court remanded the case to the Fifth Circuit and enjoined the government from removing putative class members pending the outcome of the litigation. In Friends of the Everglades, Incorporated versus Noam in the Southern District of Florida, Judge Kathleen Williams had issued a preliminary injunction blocking further installations and site expansion, as well as bringing any new detainees to the Everglades detention facility. But on September 4th, the 11th Circuit Court of Appeals granted a stay pending appeal, allowing operations to temporarily continue. In National Temporary Protective Status Alliance et al. Versus Noam in the Northern District Court of California, Judge Edward Chen granted the plaintiffs' motion to postpone the termination of temporary protected status for Venezuelan nationals on March 31st. In AM versus United States Department of Homeland Security in the Southern District of California, 2 asylum seekers are challenging the administration's policy of arresting individuals at the San Diego Immigration Court following dismissal of their cases. No updates were found this week. In National Treasury Employees Union versus Trump in the District Court for the District of Columbia, the National Treasury Employees Union is challenging executive orders that strip numerous federal employees of their statutory right to collective bargaining. No updates were found this week. In AIDS Vaccine Advocacy Coalition versus United States Department of State in the District Court for the District of Columbia, and Global Health Council versus Trump, also in the District Court for the District of Columbia, both cases involve challenges to the suspension of United States Agency for International Development funding. The court granted a temporary restraining order in both cases on February 13th, enjoining implementation on the blanket suspension of foreign aid funding. The government has filed a notice of its decision to appeal the court's decision to the District of Columbia Circuit. In Slaughter and Bedoya versus Trump in the District Court for the District of Columbia, Judge Alican granted a summary judgment and permanent injunction, ordering the administration to reinstate former Federal Trade Commission Commissioner Rebecca Kelly Slaughter to her previous role. Finally, in VOS Selections Incorporated versus Trump in the United States Court of International Trade, the court granted plaintiffs summary judgment on May 28th, holding the tariffs unlawful. For full details on these executive actions and court cases, please check the 47 POTUS app. This summary was created by 47 POTUS and narrated by an automated voice.